Okay, I think I'll start with the housekeeping things. I'm Gwen Bradley from the AAUP, and thank you for coming to this webinar today. We will be doing questions at the end using the Q&A pod, which is down in the middle of your screen. If you click on it, you can enter a question. You can upvote other people's questions, and we'll take as many as we can at the end. We do have a hard stop right at 3. So I think I will let Risa and Channing get it started.
Great, thank you, Gwen. And hello, everybody. We can't see you, but we're really happy that you're here. My name is Risa Leibowitz, and I am a professor of labor and employment law at the School of Industrial and Labor Relations at Cornell University. And I'm also a member of AAUP's Committee A on Academic Freedom and Tenure. And I'm the former general counsel for AAUP. So I'll stop with the titles now and say how happy I am to be here working with Channing Cooper to present today, and I will hand this over to Channing.
Thank you, Risa. Yes, I'm so happy and privileged to be here presenting on this topic with you. Risa, my name is Channing Cooper, and I am the Deputy Director of the AFT Legal Department. And as the title says, today we are going to be talking about Title IX and what faculty should know. And I think when we were first asked to do this presentation a couple of months ago, we were approaching it from the standpoint of how do we, address the new 2024 Biden regulations. But a lot has happened since August when the Biden regulations on Title IX were implemented, from legal injunctions holding up the enforcement of the regulations to, of course, last week's election, which will undoubtedly result in the regulations being tossed out. And so in instances like this, I think it's really important to remind ourselves and understand the fact that Title IX is only a floor when it comes to addressing sex discrimination on college campuses. And now more than ever, when we have so much political turmoil, and political reshuffling in Washington, D.C., where I'm based, it's important to be proactive in assessing what our values are on campus with respect to the enforcement of Title IX, and also approach administration, whether that's through shared governance or collective bargaining, to provide our communities on campus with some real clarity and appropriate protections with regard to the administration's process on handling Title IX complaints. So I think ultimately what both Risa and I want for anyone listening to us today is to start the conversation with their colleagues on campus with regard to how you, through your AUP membership and the administration, can strengthen Title IX. Is there anything, Risa, that you want to add to that?
No, thanks. I think that's a great introduction. And so we can just launch into Title IX, I guess. And as we do that, I think we'll continue to come back to that theme of, what can we do in the face of, lots of political turmoil and change? What can we do still on our campuses to move towards the goals that we have as faculty who are, in support of our goals of gender equality, racial equality, and strong faculty governance and collective bargaining.
Great.
So thanks.
So let's start with Title IX. Title IX, it's a civil rights law that prohibits discrimination based on sex in all education programs and activities receiving federal dollars through student loans, grants, and otherwise. And the statute specifically states that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So covered institutions, including almost all colleges and universities, within the United States, must respond promptly and effectively to claims of sex discrimination. And like I said before, colleges are free in their policies and procedures to adopt more vigorous processes than those permitted under the regulations, as Title IX only sets the procedural floor. It does not set the ceiling. And so in August 2024, Biden's administration implemented new regulations, which provided additional guidance and clarity direction for how to implement Title IX, and they went into effect on August 1st. So as many of you guys probably heard through the media, those regulations got a lot of attention because they expanded the definition of sex-based harassment to include sexual harassment and harassment, not just based on sexual orientation, but also gender identity. So let's go to the legal challenges. So shortly after the regulations were implemented, federal courts issued temporary injunctions blocking the enforcement of the new regulations in 26 states based on legal challenges that were brought by Republican AGs to the provisions that clarify that sex discrimination under Title IX would include discrimination based on sexual orientation or gender identity. And then also, in addition to those 26 states, a federal court out of Kansas blocked the enforcement of the new regulations at any school or college where a student or parent is a member of 3 groups. Those groups are Young America's Foundation, Female Athletes United, and Moms for Liberty. And then in August of 2024, the Supreme Court upheld those injunctions, barring the Department of Ed from enforcing any portion of the 2024 regulations, not just the portions that have been challenged, but any portion of the 2024 regulations with respect to those jurisdictions and schools that were affected by the injunctions. So the result of this is that the Supreme Court's decision leads a patchwork enforcement of Title IX. And the Department of Education has said that it will enforce the 24 regulations with respect to any school that hasn't been affected by the injunctions, but it will also enforce the 2020 regulations that were implemented by the Trump administration at any school where they are enjoined. So what happens now with the 2024 regulations, now that we know that the Trump administration is coming into office? I believe that the Trump administration will likely, I can't even say likely, but I know they will not defend the 2024 regulations in court. They may likely settle the lawsuits pending the revision of the regulations by saying that they're just not going to enforce the 2024 regulations. And you also may see, some rulemaking that will take place, leaving us to go back to the 2020 regulations.
Okay, so what I'm going to do now, and Channing and I are going to trade back and forth today. We've worked together a lot, and and I think we both enjoy doing this kind of back and forth, and taking on different the different aspects of the discussion here about Title IX. And so, in the face of the kinds of situations that we are facing now, that Channing was just talking about, with, the new Trump administration coming in, the kind of expectations that we have of having the potential for the new 2024 regulations perhaps replaced by a new rulemaking period, and potentially going back to the 2020 regulations. We'll be going into that in some detail today. But before doing that, we're going to kind of pull back a bit and think about the AAUP in particular, the AAUP's policies and its engagement in this area, and the AAUP goals about what we want to try to actually do in this area of Title IX and gender equality issues. And so what I have here, what we have here on this slide is a list of, gives you a timeline of the way in which the AUP has been involved in these issues for many years, starting with the written policies by AAUP starting in 1984 on sexual harassment and continuing through 2012, 2016. All of these are links to the AUP website. And then also from 2019 to 2024, we've been involved with making comments to the Department of Education's proposals for regulations on regulations to enforce Title IX, and we've been responding to those regulations all along. And throughout that kind of process of commenting in writing to the Department of Ed about these issues, we're always emphasizing the AAUP's goals in these areas. It's always about how do these regulations to enforce Title IX, how do they actually promote the goals that we have in AUP? And so we're going to keep going back to these, but just to list them here to begin with, AUP's goals are to address gender inequality with a comprehensive assessment of bases for inequality. So we don't look at Title IX as detached from these kinds of broader goals on campus to say, you know, how do we promote inequality throughout the campus, not in a legalistic kind of narrow way, but in a broad sort of structural way. And then, of course, the goal of protecting academic freedom for faculty is essential, so that as we are promoting gender equality, as we're promoting provisions and actions against sexual inequality and sexual harassment, we're also distinguishing between protected speech under academic freedom as opposed to unprotected sexual harassment, so that we have a clarity there. Our goal is also to protect due process in investigations and in hearings that may affect faculty's job security, that may affect their career in various ways. And then also we're always trying to integrate shared governance and collective bargaining as central to every aspect of our employment and our conditions of employment on campus, including being central to developing and implementing Title IX policies, so that the faculty voice is central in this way. And so what I'm going to do now is just very briefly remind people of the AAUP standards that we promote and advance generally, and also to think about how those can be integrated into the work that we do under Title IX. And so there's a link here to the recommended institutional regulation 5 for AUP on standards for dismissal procedures, and you can link to those. You know, we're going to be posting these slides, and to highlight some things that apply in any dismissal case is the requirement for adequate cause, for just cause, that links any alleged misconduct to actually show that it applies to the fitness. It shows whether faculty members are not fit to teach. And so in that area, there are various ways that due process can protect faculty, including, you know, discussions towards a mutual settlement and knowing what you're charged with. And then also part of due process for dismissal under AUP standards is to have a fair hearing, one where the burden of proof rests on the employer and the institution. We have elected faculty committees to have peer review through hearing processes, a high enough standard of proof of clear and convincing evidence that the employer, the university, has to show that you have a right to an academic advisor or counsel, a record of the proceedings, the right to confront and cross-examine all witnesses. And these are the sorts of procedures that through shared governance and collective bargaining can be adopted by your institution. And these are the kinds of things that we should think about for Title IX procedures as well. And then continuing on this, that after there's a hearing, AAP's principles and procedures have in them a report by the hearing committee with requirements that the president of the university either should adopt the report, or if it won't adopt the hearing committee's report, that it actually, that the president will justify that to the hearing committee. And with regard to penalties, that not only the question of is there adequate cause for dismissal, but also whether any penalty less than dismissal would be appropriate under the circumstances. And once again, that should be built into our policies, our collective bargaining agreements, through shared governance, through collective bargaining, and thinking about it for Title IX. And so now with that, we're going to shift to taking a look at what we'll call the new Title IX regulations, and that's equivalent to the Title IX regulations adopted under the Biden administration's Department of Education in 2024, which are effective or were effective on August 1st, except for those schools where there are injunctions, as Channing discussed. And so, again, just as a reminder here of what I put up just before on the slide is the central question that we're addressing today, and we hope that you will address on your campuses, has to do with whether Title IX regulations meet AAUP principles to promote the goals. I won't go through them here again, but to promote the goals, this is exactly the same slide as I said before. And so that's like the sort of the touchstone that we're always going to be using. And I will also just introduce for you here some of the main points in the new 2024 regulations. And then we'll switch it over to Shannon, or I keep saying Shannon. I'm so sorry, Channing, because I work with somebody with that name and I keep doing that. And so just to actually make sure I've got it right, I think Channing, you're up now. I think my time is up for the moment. Is that right?
Also, Rita, I just wanted to let you know that we did get some comments that we were going in and out as far as the feedback. So we were requested to turn off our video so that.
Okay.
Okay.
Okay, great. We'll do that now. Okay.
Right, thank you. Okay, great. So I'm just going to give a 30,000 foot view of some of the key provisions in the new regulations that were implemented in August of this year. And the first is that the regs expanded the definition of sex discrimination and sex-based harassment. And these are the provisions that are subject to the challenges that are currently pending in federal court right now. And traditionally, conduct that occurs outside the college's education program or activities or outside of the United States are not governed by Title IX. But the new regulations have stated that colleges still have an obligation to address sex-based hostile environments under its education program, even when some of that conduct alleged occurred outside the college's education program or outside the United States. And last, all faculty are required to be mandatory reporters regarding student claims of harassment. We're going to dive into this a little deeper later into the presentation. The new regulations permit a single investigator model for handling complaints. This means that the Title IX coordinator and investigator may now, in the same matter, serve as the ultimate fact finder and the decision maker. The accused no longer has a right to live hearings and cross-examination. And the revised regs create a default presumption that Title IX adjudications will now be based on a lower standard of proof, namely the preponderance of evidence standard, rather than the more demanding standard of clear and convincing evidence. And the 2020 regulations allowed colleges to choose between the two standards. But the new regulations have created a default expectation that the lower standard will be used unless the higher standard has been used in comparable proceedings. We can go on to the next. Okay, great. So the new regulations, they provide a broader definition of what a hostile environment is. The old rule defined harassment as unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education program or activity. The new rule has expanded this definition to include unwelcome sex-based conduct that, based on the totality of the circumstances, is subjectively and objectively offensive and is so severe or pervasive that it limits or denies a person's ability to participate in or benefit from the school's education program or activity. And one major criticism of the 2020 rules was that the narrow definition of sexual harassment, requiring that the conduct be both severe and pervasive, and that it effectively deny the person access to the education program, led to vast underreporting and allowed for sex-based harassment to go unchecked. But as I just mentioned, the new rule expands the scope. So, for example, conduct such as repeated sex-based offensive jokes, which may not under the old rule have been considered severe enough to qualify as harassment, would now be prohibited if it was sufficiently widespread or repetitive enough to be considered pervasive. And then on the other hand, you can have instances of, one severe instance of discrimination that no longer needs to be persistent or pervasive to qualify for Title IX protection. Next. So in addition, the new rule makes it clear that harassment need not be sexual in nature to violate Title IX and be considered sex discrimination. Sex discrimination now includes discrimination based on sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. These, as I discussed earlier, have been the most controversial provision. So this is a regulation section 106.61, which remained the same moving from 2020 to 2024. It says nothing in the regulations requires a recipient to restrict any rights that would otherwise be protected from government action by the First Amendment of the United States Constitution. We put this in here because we just wanted to highlight that despite comments that were submitted by the AAUP, the Biden administration failed to provide explicit protection of academic freedom in these new regs. The AAUP had recommended that the Department of Ed adopt a fuller statement than what you see here, and specifically call out academic freedom, underscoring the need to protect faculty for presenting provocative ideas and language that are well within the scope of academic freedom.
Yeah, thanks, Channing. And I'll just tag on to that before we move on to another topic, which is that as Channing said, AAP has been continuing to say that we'd like the regulations to be explicit in protecting academic freedom, as opposed to this sort of general statement of nothing requires a recipient to restrict any rights that would otherwise be protected under the First Amendment. And we think that there should be a fuller statement of the protections, whether it's a public or a private university, that it's not only may be a constitutional question, but also more broadly an issue of academic freedom, whether constitutional or constitutionally protected or not. But I would also just add that the Department of Education and the Office for Civil Rights has clearly stated in their policies over the years and their guidelines that academic freedom is recognized as a protection of speech and expression when applying Title IX in higher education. And so that is understood through the guidelines, and it's very important to recognize that, but we'd really like it to be explicit in the actual regulations as well. Okay, so now we're going to move on to a different sort of a topic, and one that's been extremely important to faculty. I know that I've talked about Title IX over the years in many different places on many different campuses, and this question of so-called mandatory reporting is of great interest and concern to faculty everywhere I've gone, and certainly for me and on my own campus, that's of concern. And so to give you the update here on the 2020 regulations and the new 2024 regulations on this issue, there are some significant differences. Now, the term mandatory reporter is not used in the regulations. However, the regulations do discuss whether any individual, whether it's a faculty member or other individuals, are obligated to either, they can use the term report, but here they say obligated to notify the Title IX coordinator about information that the individual may receive regarding, it might be a student who says something to you as a faculty member saying, I was, something happened to me, and it has to do with sex discrimination, including potentially sexual harassment or even some sort of sexual assault, that the question is, as a faculty member, are you required to report that to anybody? Or as a faculty member, can you talk with the student? Can you give them advice? Can you, give them information? Can you offer to help them report it if they wish to? As opposed to, are you required to report? And this is a very big difference between the 2020 regulations and the new 2024 regulations. Under the 2020 regulations, and this is true even before 2020, the regulations did not mandate that all post-secondary faculty be mandatory reporters. Okay, now that's different for K through 12, but we're only focused on higher education. And so there was no mandate that post-secondary faculty report to the Title IX coordinator or anybody else. Now, some universities and colleges adopted policies making all faculty mandatory reporters, but it wasn't required under Title IX regulations. And this was one area where, as we'll discuss more later on, some universities adopted, particularly through faculty governance, adopted provisions that distinguished between faculty who were mandatory reporters as opposed to faculty who might be called assistive employees to help but not have to report. And of course, that's really important to us as faculty because of our relationship with students, that a lot of faculty are very concerned that if students come to talk to you, that they come because they trust you and want to be able to speak to you without thinking that you're going to have to report what they say. The students want to keep that as their own choice on whether to report or not. And so with the 2024 regulations, what happens is that all post-secondary faculty have been made mandatory reporters about students. And the wording is broad in terms of, do you have responsibility as a faculty member for administrative leadership, teaching, or advising? But basically that means all post-secondary, all college and university faculty will be obligated to notify the Title IX coordinator about information they receive from a student or about a student being subjected to conduct that may constitute sex discrimination. And so there really is no choice there at all. And then for faculty who may be mandatory reporters about employees, that might be your colleagues, or it might be other employees at the university. Still, there was no mandate under the 2020 regulations, but under the new regulations, the institution may, must require that any non-confidential employee who has responsibility for leadership, basically any faculty members, and has information about an employee possibly being subjected to conduct that's sex discrimination, the institution has a choice of requiring you to either notify the Title IX coordinator or to simply help the individual by giving them contact information. And so that's a policy choice by the institution. And this is where faculty governance and collective bargaining can be really important if what the faculty on the campus wish to do collectively is to have that sort of policy of saying that faculty can be helpful, but are not necessarily mandated to report to the Title IX coordinator about fellow employees. Okay, now I'll switch it back to Channing.
Thank you, Risa. So, the regulations obviously address how do you determine violations, how do you determine sanctions, and what does due process look like? And in the 2020 regulations, they prohibited offering informal resolutions absent a formal complaint, and also prohibited post-secondary institutions from offering an informal resolution process to resolve allegations that an employee sexually harassed a student. The 2024 regulations, however, give the institutions a lot more discretion and how they want to handle the resolution process and whether they want to elect to pursue formal resolution process versus an informal resolution process. They provide institutions discretion to offer an informal resolution process to resolve claims and complaints regardless of whether a complaint was filed and who the parties are. But participation in the informal resolution process must still be voluntary. So moving to the standards of proof, I think it's helpful to first define what these standards of proof are. There are two competing standards for the burden of proof in Title IX hearings, and that is the preponderance of the evidence standard and the clear and convincing evidence standard. With the preponderance of the evidence standard, the level of pervasiveness is only more likely than not, or anything above a 50-50 likelihood of guilt. Excuse me, this is the lowest standards that is used by courts. And under the clear and convincing standard, the evidence must show that the allegations are highly or substantially more likely to be true than not. So the old regulations allowed for institutions to choose the evidence of standard, but the new regulations require the preponderance of evidence standard. And as I said before, they assume that the default will be the preponderance of evidence standard, the lesser of the two, unless the clear and convincing standard is used in other proceedings, such as charges dealing with race discrimination on campus.
Okay, are you ready for me now?
Yeah.
Okay, thanks. Yeah, we realize this is a lot of information that we're providing to you, and we will be providing the slides and the recording. But I will also say that what we're providing to you is not everything, right? What we tried to do is to identify some of the key points, the main points as we summarized earlier, that were important both in 2020 and in the new 2024 regulations, so you could get a sense of the structure of the regulations under both approaches, where they're similar, where they're different. And and hopefully this will be helpful to you to not only fill in what's happening, but also to give you a sense of where you as faculty through your chapters, whether collective bargaining or an advocacy chapter and using shared governance as well as collective bargaining, all of those things, how can you use them to educate yourself and then also be part of the process of creating policies on your campus and helping to implement Title IX and the regulations. And so now we're going to be moving to the issue of due process in the situation where there may be a charge or a complaint filed against an individual. And complaints may be filed against faculty, they might be filed against employees generally under Title IX. Title IX complaints might be filed against students. So as a respondent or something's filed against, it could be all those groups. And also as a complainant, a complaint could be filed by a student against a student against a faculty member or an employee, or it could be a faculty member or an employee who's filing a complaint against a colleague, against a supervisor, manager, against somebody in the administration, or it could even be against a student. And so within that kind of structure, you have the question of, well, what are the due process provisions? What are the requirements as well as the rights that individuals may have in their roles as complainants or as respondents, those against whom allegations are made. And this is one of the situations where you have some very significant differences between the 2020 regulations and the 2024 new regulations. And this is also in some ways surprising because the 2020 regulations are ones where there's more due process that is provided and made available for both parties, but maybe even more important if you're a respondent in the situation. And the AAUP's position has been very much in favor of having significant amounts of due process when one is charged with a potentially life-altering event. And if you're charged for sexual harassment or some kind of sex discrimination, then that could really change your life, whether you're a student or a faculty member. And so in this instance, using our principles, our comments to the Department of Education have been consistently in favor of having full due process. And the 2020 regulations adopt more due process, even though under the Trump administration, clearly there was significant hypocrisy and contradictions with having somebody like Trump heading up an administration in which there was greater due process provided. So we won't get into the motives for that, but it really is quite different. And AAUP still takes the position that there should be full due process. So with that, let me just specify some things. Under the 2020 regulations, the single investigator model cannot be used, as opposed to under the new regulations, an institution may use a single investigator model, meaning that the decision maker for a Title IX allegation may be the same person as the Title IX coordinator or the investigator. And so our position from AAUP is that really creates it skews the system, and it does not create an impartial kind of decision maker, and it also doesn't involve peer review that's so important for AAUP principles. So that's a really big difference. But I also will remind you that the 2024 regulations are such that this is the floor. That is, the institution may use a single investigator, but is not required to. And so through collective bargaining, through shared governance, our chapters can actually work on bargaining and negotiating to adopt policies that provide more due process above the floor. There's no ceiling, there's a floor. And that's true for both the 2020 regulations and the 2024 regulations. So back to the 2020 regulations, colleges and universities grievance processes must provide for a live hearing, as opposed to the new regulations where no hearing is required, even though it may be provided. And I would just note that if there's a live hearing, it doesn't mean that you have to have a live hearing. It's just that it's made available if one of the parties wishes to have it. Again, under the 2020 regulations, the decision makers cannot be the same person as the Title IX coordinator or the investigators. And these yellow highlighting points here is the point that I was just making, that in both 2020 and 24 regulations, the college or university may adopt additional provisions in its grievance procedures that would go above the minimum required, as long as they apply equally to all the parties. Also this is just in the 2024 new regulations, what we have are 2 levels of grievance procedures. The first applies to any sex discrimination case. It's a lower level of due process. Whereas if there's a sex-based harassment case under the second one, the 0.461, there are additional due process requirements where a student is either complainant or respondent. And here we outline some of the differences. There are others, but we're identifying what we think are key ones so that you can see the minimum level for all cases would not require written notice of complaints, meetings, etc. Whereas if you have a student complainant or a student respondent in a college or university, written notice of complaints, meetings, hearings, etc., written notice is required. There is written notice required under the minimum level of what the determination is of a sex discrimination determination or appeal. For the minimum level, there's an equal opportunity to get access to evidence if one of the parties requests it, as opposed to the higher level where there's simply equitable access to the evidence provided. Under the higher level, you have a right to an advisor at any stage, which is not required at the minimum level. At the higher level, if a live hearing is provided, each party may actually propose questions, and there may be questioning by an advisor of the witnesses, as opposed to the lower level where there's no provision required for a live hearing. There would be the opportunity to present and respond to evidence during the investigation. So you can see the differences in the 2 levels. Then, apart from determining whether you're guilty per se, guilty in air quotes here, whether you're responsible for having committed the allegation of misconduct, under the 2020 regulations, there's a requirement for hearing, but there's no requirement provided that's defined in any way with regard to what would be the appropriate disciplinary sanction if somebody is found responsible. Under the new regulations, there are required prompt and equitable grievance procedures for determining sex discrimination or sexual harassment, and arguably there could be a separate type of hearing to determine disciplinary sanctions. And so the importance here has to do with, even if, let's say, a faculty member is found to have committed a violation, some sort of, let's say, sexual harassment under Title IX, the question of what should be the appropriate punishment, the appropriate sanction, can raise a separate due process issue. So can you negotiate bargain for policies, whether in the collective bargaining agreement or separately for the university policies, to have peer review, faculty on hearing boards, so that the sanctions that might even go up to losing your job, dismissal, losing tenure, that can be done through higher levels of due process, because you can go above that floor as opposed to only staying at a minimum level. And so now we're going to move to ways of incorporating AUP principles and standards in shared governance or in collective bargaining to continue the discussion that we've just really started in this last kind of discussion of due process. And so continuing on those lines, we have identified some areas for negotiations where you can go above the minimum when you get involved through your chapters and collective bargaining and shared governance. In defining sex discrimination and sex-based harassment, including academic freedom. And, you know, as we're also thinking about some of the objections that we see in the cases dealing with injunctions and the potential new regulations under a new Trump administration, defining the protections as broadly in terms of gender-based protections against gender-based discrimination, defining that as broadly as possible. Title IX offices and processes, faculty should be engaged in hiring who's in those offices and engaged in training hearing panels to bring our goals and policies in. We can do things like require written documents at all stages, even if they're not required by the regs. We can have more informal resolution processes where permitted under the regs as a possibility. And at least under the 2020 regulations, we can define mandatory reporters in ways that narrows the scope of faculty who must report. And we can also develop policies to help all faculty in providing support to our students and our colleagues. And some additional examples of negotiations for higher than minimum standards have to do with investigation and hearing processes. You know, the right to an advisor, having hearings as possibilities and not having a single investigator model, using a clear and convincing evidence of this as the standard of proof as much as possible. And I'll just dwell for a moment on this last one, to avoid the any dual system of due process for sexual misconduct issues. Because that happened under the 2020 regulations, where there were Title IX regulations with a lot of due process, and then for so-called non-Title IX misconduct, the due process went down in another system. And so as faculty activists, we can do more to make sure that policies are adopted that provide higher due process across the board. Okay, now I'll send it back to Channing.
Thank you, Risa. And here we just wanted to provide you with a few examples, policy examples, where you can see our affiliates have gone through shared governance or through collective bargaining, and where they've been able to raise the standards when it comes to protections, Title IX protections on campus. So for Western Michigan University, they had a provision on academic freedom, where it says, in cases of hostile environment, sexual harassment, and subject to applicable law, Western and the chapter recognize that the classroom constitutes a setting which involves wide latitude in the presentation and discussion of ideas which are germane to the subject matter being taught. And I don't know if you'll recall, but earlier in the presentation, I discussed how there was the new regulations did not provide an explicit call out or protections for academic freedom. And so in this way, through collective bargaining, the affiliate chapter has been able to memorialize, you know, what are the values when it comes to academic freedom on campus. And then here at University of Oregon, we have a section, these were the policies that were in place with regard to mandatory reporting prior to the 2024 regulations being put in place. So this is when campuses had the discretion to determine who were mandatory reporters. And as you can see, through shared governance, I believe, this policy was negotiated, was that where you have defined clarifications or a clearly defined list of who will be a designated reporter versus who will be somebody who is responsible for assisting employees or students when it comes to complaints, and then who will be determined as a confidential employee. And this is being you, Risa. I can.
Okay, yeah.
Sorry.
Yeah, I'll pick it up. It's really the same with regard, the same University of Oregon, where you can see as of August 1st, what had been narrowing the mandatory reporters has been changed because Oregon is not one of the institutions under the injunction. And so they have expanded the mandatory reporters to be all faculty. And that shows you the difference. And then we have two slides from Illinois Wesleyan you might find interesting. This is not through a collective bargaining agreement, but through their, the policies of the university and the faculty handbook. They have provisions here under the Title IX procedures that recognize academic freedom in, quite a full way. And then in the next slide, from their sexual misconduct policy provisions and their faculty handbook, in both of those situations, there are increases in due process in faculty dismissals that they've created. And so we wanted you to see some examples of ways that the minimum has been built on. And that's the end of our slides. We had a lot to do, and I know I can see, I haven't had a chance to look at the question, but I can see that that there are lots of questions. So, Channing, how would you like to handle the many questions?
Well, I know that we have a hard stop at 3. I don't know. Well, first I want to say, I know there were several requests for the list of states and institutions that are going to be impacted by the injunction. I included in, as well as some of your colleagues, which thank you, included links in the Q&A chat box that will provide you with a search tool or either a list of those institutions that have been impacted. And the other thing that was troubling is that with those 3 groups that I had called out, I forgot, like Moms for Liberty and whatever the other 2 groups were, is that's an if your institution doesn't have one of those groups on campus, all they have to do is just set up the group on campus, and then all of a sudden your institution will be impacted by the injunction. So it will be a growing list. But like I said, come 60 days, I don't expect for the Trump administration to be enforcing the 2024 regulations anyways.
Okay.
Do you want to just, let's see.
We could just start on the first question. It's a good one.
Okay.
The question is, what is the AP's position of impacts on academic freedom for people who study and teach on sexual violence, but cannot allow students to engage and talk about it openly in our courses due to mandatory reporting requirements? And of course, that may have existed prior to the 2024 regulations because some universities adopted those kinds of policies already. And so, I mean, our position is that this is an example of the way in which policies about mandatory reporting, which may actually have a motivation to try to help students, actually can undermine our ability to be helpful for students. If we're in a situation where we have to tell our students, if we learn about certain types of information that indicate that somebody may have been subjected to sexual harassment or discrimination, that we're required to report. This is something we have to tell our students so that they can make choices. But this is why we have advocated so strongly for narrowing mandatory reporting. Shall we move on to this? We have so many questions. I'm sure they're all great, but we only have a few minutes to address them.
And there's also questions, Risa, in the webinar chat, one where it says, it seems as if what you're telling us is that each institution can upgrade their own Title IX interpretations. Is that correct? Also, in the case of a faculty member persistently misgendering a student despite being told pronouns and names, is that a Title IX violation if the student interprets this as a hostile environment? So yes, it is correct that you can, like I said, it's not to sound like a broken record, but it's a Title IX, the regs are a starting block, they are a floor. So yes, the institutions have the discretion to strengthen the standards that are set by the Department of Ed. And in the case of the faculty member persistently misgendering a student, we're not providing, legal advice, so we can't answer that question. As far as legal guidance, but what I can tell you is that just based under the 2024 standards is that they're looking at whether or not the conduct is, well, first, yes, gender identity is, you can be deemed to be engaged in discriminatory conduct based on somebody's gender identity. So that's one. And then two, they're going to look to see whether or not the conduct is pervasive or severe. And then they're also going to look at both the objective and subjective standards. So whether or not the individual who was the target of the misgendering felt attacked, and then whether or not using the reasonable person standard as well. With that said, I hate to just keep going back to, because the reality of what's coming in January is that gender identity will no longer be included in the definition of what can be determined as sex discrimination.
Yeah. I would just add, that this is one of those areas where I would say a couple of things. One is, once again, get involved with, as much as possible, I think for all of us to get involved with writing policies, developing policies on defining sexual harassment, and including in that, making sure that those are clear when there's harassment and when there isn't. And also making clear that academic freedom is part of defining sexual harassment and when it is not. But the other thing is that we can do more with educating ourselves and our faculty. It doesn't have to be simply Title IX issues. That if there are faculty who are misgendering students and we think that's a problem, then raise that at faculty meetings. Have those issues as discussions so that we educate our colleagues, as well as looking at regulations. I see there's lots of questions about mandatory reporting, lots of concerns about it. And so I think this is one area where more discussions are really important to have about this. And we'll see what happens with the regulations, because under the 24 regulations, if they apply, you have to have mandatory reporting. Under the 2020 regulations, if they're reinstituted, we'll see about what happens with mandatory reporting.
I just want to jump in. I'm sorry to cut it off with so many questions still there, and there's a lot of great questions and also some comments that are addressing other people's questions, but we do need to stop. So thank you so much, Risa and Channing and everyone for coming. Risa or Channing, do you have any last words?
Just thank you, and remember that we're all actors in this. And if we join together collectively, not only we get the social benefits, and I mean social broadly in terms of standing together in hard times, but we can actually engage in these issues in ways that are meaningful on our campuses.
Thank you.
Thank you, everyone. One.